Any universalized reading of any norm of law has potential consequences, since it implies a certain approach to deciding the present case and like future ones. Will the situation be preferable or more acceptable if in the implementation of law this rather than that reading of it is preferred? Juridical consequences of this kind, consequences as implications, do not involve long-range causal predictions about the impact of decision-making on human happiness. They could not, and they should not. On the other hand, a legal system that requires a person to sleep the night on a freezing sidewalk rather than to take shelter in his own car would be a curiously inhumane system. On the opposite side of this particular argument, it can scarcely be said that the common sense answer in this case opens the door to drunk drivers who can pretend they were only sleeping off a hard night in their car before driving off in it. It could be objected that even this rather restricted conception of consequentialism amounts to recognizing that the judges are in a position of quasi-lawmakers. Policy, it might be said, is for the legislature, law is for the judges. The requirement of coherence, the second C, affords a reply to such an objection by setting an outward limit on the use of value-based or policy-oriented consequentialist arguments in the legal judicial setting. The law is not only a matter of relatively detailed rules spelled out in statutes. Codes of law express principles long honoured among lawyers, and common law systems honour similar principles. Legislatures may sometimes make laws on a simply opportunistic basis, but more commonly they do so with a view to implementing some political principle or principles to which they desire to give legal effect. Over time, in the interpretation of statutes and in the development of case law, courts elaborate principles of law relevant to its interpretation. These are ones that the courts characterize as expressing a sound basis for legal duties and rights of all sorts, real as well as personal, and as expressing the underlying principles of particular rules of law making up a particular branch of law. Individual decisions, even if justified in terms of quite strong consequentialist considerations, can also be presented as instantiating some important general principle of law. To that extent, they are shown not only to be desirable in consequentialist terms, but also to belong within the law viewed as a coherent body of norms. Where no such principle can be found, the wise judge holds back from pursuing consequentialist arguments into wholly new ground. Coherence with principle is a key element in the justification of a truly justified decision. A further and perhaps yet sharper limit is found in the third of my C's, consistency. However desirable it might be to keep drunken horseback riders off the highways on similar terms that apply to drunk drivers, there are limits to the pliability of language and the malleability of laws expressed in ordinary language. It may be that motor vehicles do not have to be wheeled vehicles. A hovercraft moving on a bed of air along the highway is certainly a vehicle, but a quadruped animal is equally definitely not. Horse-drawn vehicles are not vehicle-drawn vehicles, unlike a car with a trailer. To convict the horse rider for breach of the drunk driving statute is simply not consistent with the terms of the law, and also therefore it violates the principle according to which there should be no criminal trials save for offences clearly proscribed by pre-existing law. Consistency sets a firm limit to justifiability. But again, it operates after the legal text has been interpreted. One must not act inconsistently with the text on the best available interpretation of that text. What the best interpretation may be can then lead one back into issues of consequentialism and arguments of legal principle or of legal analogy expressive of the requirement of coherence. The three C's hunt as a pack. They don't apply sequentially in anything like an order of lexical priority. And that is the end of the third section. And now I come to the fourth and final section of the paper, which has the heading, So What's Reasonable? To conclude, we return to the value question of what is reasonable, so often raised in common law systems, but having direct parallels and close analogues like proportionality in other legal systems. If there is no lexical priority among the three C's, how are they supposed to work together? The answer, I believe, is in terms of the permanent endeavour of the law to achieve justice among people. This can only be done through a process of reasonable adjudication. So, what is reasonable? The very question of this concluding part of the lecture. The answer lies in the link-up between reasonable reasoning and reasons. Clearly, a person is practically reasonable only if she acts for reasons. Indeed, only if she acts for good reasons. Where reasons conflict in some way, she seeks to ensure that she acts on the basis of the reasons that survive deliberation as the strongest of those that are fully eligible for consideration. The problem, which has become almost a philosophical commonplace, is that many good but not necessarily compatible or even commensurable reasons bear upon our action, all indicating some element of the good, the right, the obligatory or the permissible. Provided we fulfill our obligations and avoid wrongdoing, it is reasonable to try to act for the best among the options that are permissible. This implies a capacity to weigh and consider many factors that bear on one's decision. This is obviously, by the way, a feature of 3C's reasoning. The opposite of reasonableness is one-sidedness in reasoning. It is ignoring some reasons and thus overvaluing others. The manufacturer, whose in itself reasonable pursuit of profit focuses on this to the exclusion of duly considering the welfare of employees and of consumers, acts unreasonably. Reasonableness, then, requires taking into account everything that is relevant and thinking through what weight it is appropriate to give to different considerations. In situations where one knows that time for deliberation doesn't exist, it requires the pre-adoption of routines or rules that will tend to eliminate the impact of the worst risks. It also requires acknowledgement of the possibility of people in good conscience differing about the degree of weight different considerations bear. Reasonable people are those who acknowledge that different people who try equally carefully to think through to a good solution of a practical problem can genuinely come up with different answers. This doesn't mean that all differences or all disagreements are between equally reasonable proposals or courses of action or decisions. But it means that some are, and that reasonable persons cannot be dogmatic adherents to their own solutions, who always dismiss similar arguments of others that reach somewhat different conclusions. Reasonableness involves taking all reasons into account and weighing them as best one can. It also involves respecting others who take a similar careful view of the situation, but who can account for differences in their approach from that which commends itself to us. It is then obvious why reasonableness can matter so much in law and can give rise to such finely poised evaluations in cases to which it has material application. Did the defendant take reasonable care? Was the tenant given reasonable notice? Did the evidence exclude all reasonable doubt concerning the accused person's innocence? Did the minister act unreasonably in refusing to allow planning permission for some development? And so on. That more than one answer can be reasonable does not imply, I say again, that every difference of opinion is reasonable. This has a bearing on the celebrated one right answer dispute. Clearly, it can often be the case that the difference between parties that leads to litigation is not truly reasonable, though lawyers exercise all their skills to put forward the best available arguments for the weaker side. But if in truth the weight of reasons favours the other view, and the opposed arguments do not pass or do not so fully come up to the same threshold of reasonableness, then the only proper answer is in favour of the truly more reasonable outcome. There is often a clearly right answer, even in closely disputed cases. But this is not always so. And when it is not, the only solution is the majority vote in the final appeal. That is then the only reasonable solution. Thank you.
Thank you very much, Professor MacCormick, for a brilliant and very enlightening paper. And I'll go back to Portuguese for a second. O que nós vamos fazer agora é alternar perguntas que vão ser feitas por vezes em nosso nome, por vezes em nome do professor Ronaldo, e assim nós vamos fazer uma dinâmica das perguntas, né? Vamos alternando. O professor MacCormick, eu vou fazer as perguntas, obviamente, o professor Conrado também em inglês, porque para o benefício do professor MacCormick, porque nós não temos tradução simultânea aqui, enquanto estamos gravando esse vídeo. Então, posso começar se quiseres, Conrado, que eu gostaria de começar.
Pode fazer.
Bom, vamos lá. Professor MacCormick, I will alternate questions. There's one thing I've always meant to ask you, and I'll take the opportunity to do that now. And that brings together part 1 and part 3 of your paper, the aspiration to justice in law and also the idea of coherence. Joseph Raz in the late 80s, early 90s, published a very forceful argument against the idea of coherence, in a sense. Well, it's certainly against the idea of coherence, and trying to basically asking what's the value of being coherently wrong. We're not talking about major injustice, the injustice that kills people, the minor injustices. And what he says is that, yeah, of course, sometimes coherence can be a means to unpack what the legislature wanted to say anyway. But sometimes it's so far-fetched to think that the legislator could actually have thought about the case. And in those cases, what he seems to be claiming at that point is that there's no point in being coherent, because it's better to go for the right answer morally, as opposed to being coherent to an institutional practice. So what I wanted to ask you is basically to explore the connection between the aspiration to justice and coherence, when coherence can actually be seen as being morally, if not deeply misguided, at least know the best possible solution. And the idea would be whether, or the underlying question is whether coherence would have itself any moral or political value.
Mm-hmm. Well, I think the answer is yes, in the sense that more rational orders of human conduct and existence are always preferable to less rational, and coherence is one condition of rational conduct. Joseph Raz is, however, right to say that in circumstances of extreme evil, for example, one would care very little for the coherence of the evil program. I visited Auschwitz for the first, and I hope the last time in my life, last summer. Now, it might be that the slaughtering of Jews and others was managed in a coherent way, and that doesn't improve it in any way. It doesn't help. But then that takes us back to the point that we're talking here about coherence in legal justification. And if you take the view that even when laws are unjust, they nevertheless are so through a failure to realize the aspiration to justice that's built into law, then you say, well, coherence in legal justification is an attempt to get the justice of the law right, to be rational in that, and hence because the law itself has a certain value orientation, coherence in the pursuit of that value orientation is good. You might say, just to take a parallel, I was thinking not so long ago, it may be that a certain university, maybe this university, perhaps, doesn't take fair account of difference of linguistic background in the exam system. You know, a student whose native language is English has the same time to write an exam answer as a student whose native language is Portuguese or Spanish or Swahili. Yet, for native English speakers who are dyslexic, we give extra time. Now, I think myself that's a bit unfair, but I don't think the exam system is designed to be unfair. People are doing their best to take fair account of all sorts of things. I think it would be more coherent if we allowed extra time for foreign language speakers in the exam hall. But, you know, there are counter-arguments, and, you know, we may think here again, two reasonable solutions exist, and we've chosen one of them. But to say that coherence would be of no, that an appeal to coherence has no value relevance in this sort of setting is obviously nonsense. And Joseph was wrong about that.
Okay. Well, Professor MacCormick, I'd like to ask you to elaborate a little bit more on your idea of consequentialism. And specifically, I'd like to ask you whether it is fair to say that the difference between your version of consequentialism and other versions of consequentialism, and I have in mind especially the one suggested by law and economics, that the main difference is that your version requires to balance consequences with the values of coherence and consistency. And consequentialist arguments are very strong and threatening sometimes when, for example, constitutional courts are judging the constitutionality of huge economic plans, for example. Brazil has some examples of this kind of threat in our recent history. Mm-hmm. So how would you how far would you accept outweighing coherence and consistency in the name of consequences when these consequences are extremely serious from the economic and social point of view? Is it compatible with your version of receipt?
That's a very, very interesting question. The little example I gave in the talk is, I think, not unrevealing. It was a real case. A real footballer had this misfortune last New Year in Edinburgh. And it does seem to me they were saying, well, look, if you convict in this case, you really are saying to people, the law requires you, in this case, to, you know, risk freezing to death on the sidewalk rather than take sensible shelter in your car. Now, a law which requires that is an inhumane law. And I don't need to ask how many people will die, or I don't need to big-scale utilitarian calculations in that kind of case. The other side, I don't think I need big-scale calculations to say, moreover, be taking a sensible and tolerant view of this misfortune doesn't open the floodgates to lots of people to go drinking and driving. No. So that's a fairly restricted look at what I call consequences, of the practical implications of what one's deciding, not the long-range outcome. There are different areas of law. Things like antitrust law, competition law, do require taking economic evidence and going into the question of what do certain trade practices tend to generate. So that, in effect, if the legislature or the character of a branch of the law is such that we are to take into account the economic impact of a certain course of conduct, that opens out the scale of consequentialist argument very considerably, though it doesn't, in my view, ever cancel the issue of coherence of principle and consistency of interpretation with the text. So I'm not sure if that's a satisfactory answer, but yes, as far as I can go just now.
Yes.
I just wanted to ask you a more exploratory question. As I was reading the idea of reasonableness and about that in the fourth part of the paper, I was wondering whether, and you envisage any different or any relation between the idea of reasonableness and principles of toleration, political toleration, because some of it seems to be leading towards that. I was talking to Neil Walker yesterday, and we were talking about toleration being having different sorts of enemies. One of them is the fundamentalist, the other one is being intolerant. But also the dogmatic, someone who doesn't accept that there might be a reasonable disagreement, seems to be someone who is not tolerant in some respect. I was just wondering if you're expecting or hoping to explore that connection in the future, and whether you see that connection as being relevant.
I hadn't thought of it, although a book I wrote long ago called Legal Right and Social Democracy does something about that. But you're right. The case I figured as the opposite of unreasonableness is usually a matter of being one-sided. I mean, there's complete unreasonableness when you pay no attention to reason at all, irrationality, unreasonableness. But people who are not fully reasonable are usually one-sided. Aristotle has stuff, about the need to take the mean between the extremes. And I think you're right. Intolerant people tend to be one-sided. They can see one truth so clearly that they exclude the possibility of other truths or other aspects of the same truth. So yes, there's a link-up between my conception of reasonableness and the obligation of tolerance. Yes,
thank you.
Toleration. Yes.
Well, Professor Ronaldo asked us to ask you whether you are becoming closer to the working and what today can be seen as similarities and differences between your theory of argumentation and interpretation and Dworkin's one. And my way to formulate it, that's a question I also wanted to ask you. Putting aside all the eloquence of the Dworkinian style, isn't it possible to say that Hercules is quite close to your model of the reasonable judge, and is it reasonable to expect that Hercules is a judge that can be subject to a majority rule? I never seen Dworkin taking this consideration into account, to think of a constitutional court which is a collective court composed by Hercules deciding together. It's something difficult to
Yes.
imagine. I know.
Well, it's a very obvious feature of all the legal systems of all the constitutional democracies in the world today, that they have final constitutional or final appeal courts with a plurality of judges, and they all have a rule of majority decision, although they all also try to avoid the necessity. They prefer unanimity if they can reach it, but they can't always reach it. So to that extent, Hercules hunts in teams, not as an individual. If you say that the issue is what a judge would decide, rather than what a court would decide. Hercules, in Dworkin's argument at one stage of it, was a heuristic device. Okay, we always are faced with finite human capabilities when we try to deal with legal problems. If we weren't finite, could we get everything correct? And for that purpose, I think Hercules is a useful rhetorical, argumentative device. I think the difference, probably, between my work and that of Ronald Dworkin is that, in a certain sense, mine has always been, if not more empirical, at any rate closer to the facts. I've always been more interested in studying and analysing specific legal materials. And I think also, I would want to claim, I've probably taken a more widely comparative view than Dworkin mainly has, which is just a matter of personal approach and interest. So that I think I'm perhaps better at accounting for the ways in which, the elements of which, a reasonable argument is built up. But I differ less and less from him on the big question. Well, are there ultimately right answers? There's a very distinguished Australian judge, David Hodgson, who's a Justice of the Supreme Court of New South Wales, who wrote a book long ago called Consequences of Utilitarianism, which was originally a PhD thesis done with Herbert Hart in Oxford. And after a talk I gave in New South Wales a few years ago, he wrote to me and said, "You're quite right that there's, always in the final issue a question which approach is reasonable." But he said, I would say, I as a judge would say, that really quite often you come up against a situation where you have to concede that that both approaches are pretty reasonable, and you have to make your best guess between them, and reasonable judges differ. It may be, therefore, that the possibility of what Dworkin called the tie judgment, where there's equal weight on either side, is more frequent than he suggests. And perhaps it's exactly in that sort of situation that there's need to have a rule of majority vote in the Supreme Court, or some other tie-break, however the President votes. It doesn't matter what the tie-breaking rule is, but you have to have a reasonable tie-breaking rule. So there's a lot in common. I've learned a huge amount from Dworkin over the years, but there are differences, at least in detail, and I think in argumentative strategy.
Another of sort of Ronaldo's questions is, a lot of what has been written in political philosophy recently referred to the difference between the rational and the reasonable, roles being the most obvious example of that. And what he wanted to ask is how you see the differences or connections between rationality and reasonableness, if they deal with different things or they're somehow connected, and how each of them relates to the idea of reason. Mm-hmm. I suppose that's the question, is it?
They're very closely related. I'm not sure if one can give a single all-purpose answer, but I would be inclined to say this, that rationality is a threshold concept. Animal behavior is only rational to a restricted extent. Human behavior is capable of being rational to a high extent. We can take mathematical calculations, we can do all sorts of other different kinds of logical reasoning and so on. So we are rational creatures in the sense that we have these faculties. And our behavior is rational whenever we're exercising these faculties. Reasonableness, I think, is a matter of success in exercising these faculties. Rational beings act for reasons. Reasonable beings act for good reasons, and are good at weighing the reasons that bear upon their action. Now, there may be other contexts in which one would phrase these differences differently, but I think in this context, rationality, I would say, is this kind of threshold, and reasonableness is to do with evaluation of conduct over the threshold.
I think that brings us to a close now. I'll thank you later on, Mr. MacCormick. I'll just say a few words to the audience. Bom, então eu gostaria, em nome da organização do evento, eu vou fazer isso daqui a alguns segundos, de agradecer ao professor MacCormick, em nome de todos nós, e em nome especificamente do professor Ronaldo, da professora Catarina. Eu vou, então, agora agradecer ao professor MacCormick em inglês, speaking for the organizers and everyone. I just wanted to thank you for a brilliant opportunity to dip in some of the most important questions in legal reasoning and legal interpretation, and thank you very much for a brilliant paper and for your availability.
Thank you for asking me, and again, apologies for appearing only at remote controls.
Thank you.